right. I have been stopped by the police. I have proof of it. I have a cameras. Those police have stolen me money when they arrest me in NDUNG'U. And the case is absolutely not right. The people who have made the denunciation have absolutely no right to do it. Those police are all thieves. They arrest me, they steal my money, they steal $7,000 from me.
It's actually afternoon. Yes,
Oh, sorry.
Yes, good afternoon.
I'm still catching up with myself.
No.
You have sat in the places where I'm remanded seat, maybe. I will start with Mr. Luke's matter and then proceed to Mr. O'Malley's matter. Now, do you wish for the record, Mr.
And therefore, we beseech counsel to bear with us because I'm also an advocate. When counsel says that he does not know why advocates are meant to wait, I'm also an advocate and I'm waiting. It's not my liking. And therefore, let us just be patient. Once this is cleared, we should be able to take clear and move on. It's not always happening. It's just the first time it happens.
Already, that as soon as it's ready, it's brought. So if they can proceed with that process. I have a hearing at 2:30. I want to be able, and possibly that, yeah. Okay. Please, uhakikishe kwamba wakili aongee na watu wake kabla hatujakuja. Okay, so we wait. You can talk to your advocate. File is marked as. All right. All right. Let me proceed with Mr. Wandu. In opposition to bond?
I will be the next.
Benjamin have been charged with obtaining money by false pretenses, contrary to Section 313 of the Penal Code.
Yeah, it's quite long, so if you get
particulars on the 20th day of January 2025 at Diamond Trust Bank, account number 0754393002, Riverside Ranch, within the Republic of Kenya, being a director of Apex Connections Limited, a corporate body, with intent to deceive, jointly and fraudulently obtain $93,000 from Mercury Ferdinando G, while purporting that you are in a position to transport by air 750 kilograms of high-value cargo from Kenya to Dubai, a fact you know to be false. Is it true or not true?
So, 9 doesn't have the intent to deceive. 9 weeks, on January, Riverside branch within the Republic of Kenya are jointly and fraudulently. Yours has intent to deceive, sorry? Yes? Is there a problem? Are they were not identical? They were fair differently?
That's
That's what I thought I had seen. 9 has 14, though. All right. Can you put your house in order? Mr. Waziri, will you allow them to put their house in order?
This man has been in custody for 24 days. People you are bent of punishing his crime, smart and control everything. And it's true you are not different from what I have and what I have. But I have been preparing it the whole morning and the whole afternoon. It's becoming a saga.
I don't see anyone who's trying to trouble senior crime. I want to propose this because the IO insists that they are getting charges. I know initially he had brought a charge of 12. And charge number 5, where there is a firearm, there was 2 Glock pistols put in one charge. I told him, no, we cannot do this. Each Glock pistol has to have a separate charge. This is why now we bring the charges to 14. So put the one you have to 14 is the right one. So that we don't have any trouble and we don't waste the cost time. Why don't you work with that one 14 charges? Then we take plea, then I'll regularize this with Lion Senior. So
How can my client take a plea without a charge? What is it? What do I have? We cannot dispute documents before the court. This is a charge given to me. How can they tell us they are ready when they got in this kind of position? But I'm fine. Give us copies, so that we can take it. I'm fine. I'll take it. But I would like it to go on record. The kind of fiasco we are going through.
Know now before we take this.
I need to just move on with what is before us because I have a number of matters.
Can the court assist us
I
if
finished.
it's free?
I finished. Let's do what is before us. Let's take Mr. Shalim, read the charge. He's not before me. What is before me is Jean Maron, and that's what I'm going to do. Shalim, please read the charge.
Riverside branch within the Republic of Kenya, being a director of Afrex Bridge Connections Limited, a corporate body, jointly and fraudulently obtained $93,000 from Mercury Ferdinando G, while purporting that you are in a position to transport by air 750 kilograms of high-value cargo from Kenya to Dubai, a fact you knew to be false. Is it true or not true? Account number 075431303, Riverside Bank,
never had the possibility to explain the story of it. The plane was there, but the people are going to pay the total. It's absolutely total cost. It's not true.
So there is not 13 others like that. So
Okay.
you have to do that. Just tell me whether it's true or not.
Okay.
The rest your lawyer will do.
Being charged with Country being charged with obtaining money. That holds pretenses contrary to section 3 of the Penal Code, particulars in the 23rd of January 1995 and contacts with Persons Limited FC situated at Bombay House and noticing an offer to the Republic of Ghana to the Director of Affairs with Persons Limited contacted Sweden with the Unfederal Evidently obtained $7,000 from Miguel
One.
This
One. Not one. It's one.
one Bronzer by proposing that in a position
Can you have a copy of the agreement? Jean?
Just have a seat. Just have a seat. So you there's a way that
Attachment page collections limited offices situated at Mumbai House and Milton Airport within the Republic of China, being a director of Attach Bridge Connections Limited, a corporate body, jointly and fraudulently obtained $7,000 from one Bronzer by proposing that you are in a position to prepare a bank account in China to Dubai and continue to be false. Is it true or not true?
just a quick instructions coming on this and you also claim on behalf of the company director.
Yes.
Pretense, contrary to section 313 of the Penal Code, particulars in the 25th day of January 2025 attaining place within the Republic of China via revenue account to fraudulently obtain $21,500 from also by proposing that you are in a position to prepare a bank in China to Dubai and continue to be found in the China trade. Contrary with being charged with obtaining money by false pretenses contrary to section 313 of the Penal Code. Particulars of the 21st of January 2025 attaining place within the Republic of China with fraudulently obtained 21,000 Swiss francs from one until by proposing that you are in a position to transport bank from China to Dubai and continue to be false. Is it true or not true? Complied with being charged with being in possession of firearms, firearms certificate pursuant to section 4.1, regarding section 3.8 of the Firearms Act, Cap 113 laws of China, in possession of firearms of ammunition, 7.65mm caliber without a firearms certificate. Is it true or not true? In time, with being charged with being in possession of ammunition without firearms certificate, section 4A, either with section 3A of the Firearms Act of 113 of China.
apply for reasonable bail terms pursuant to the provisions of Article 49 and specifically Yana Article 49 1H.
Maybe just before council proceeds, our thinking is that bail is one of the rights that are provided for under the Constitution, but subject to some limitations. We have already filed an affidavit dated today, signed by the IO who is in court, which affidavit we have fronted some reasons, compelling reasons as to why it was application. It is for us to prove those compelling reasons which we have cited in that affidavit. And as such, it is for the prosecution to go first because it is our application in opposition to that right to bond as granted under 49(2). So that he will now respond. That is our reasoning. And I feel we should go first and council can now respond as to why he thinks our reasons are not compelling.
It's expressed very clearly in the Sawe case. My client has taken plea. Surely, the most basic and fundamental right is his right to plead for bail. I was about to tell Your Honor, I have been served with an affidavit in objection, but he has the right to make the application. Then he responds, and then I can address the court. And that is precisely what I want. But they cannot start by saying, don't give him bail, even before he has applied. Suppose he doesn't want to get bail, he wants to stay in Langata. So, Your Honor, I urge you to permit me to just make my basic application. I will let my learned friend indicate his opposition. I'm quite ready, Your Honor, to respond to him. But the first person would be my client. To block my client from every civil right that he has. And that is why you find my very good friend here jumping the gun. But it is his right to do that. So, Your Honor, I just wish to express that my client has instructed me to apply for lenient or reasonable bail as expressed under Article 49H. The provision, Your Honor, demands that bail be reasonable. I urge the court in doing that to consider the presumption of innocence. My client is presumed innocent under Article 50. And I also urge the court to consider the fact that my client has been continuously in custody for 25 days in the course or since his arrest to the time they came for apprehension report and today. I wish to indicate to court that my client is ready and willing to abide by any conditions that Your Honor may impose for the purpose of bail. Your Honor, I wish to also urge the court at this point to make an order that we be supplied with all materials that the prosecution, copies of all materials that the prosecution intends to use in this matter, and we would wish to be supplied with those details in a break possible. I am minded, Your Honor, of the affidavit in opposition to my request for bail. I intend to address you on those matters and the affidavit itself after the state has addressed you. But considering the period my client has been incarcerated, we would have hoped that at least in the interest of justice, they would not object to bail. Thank you, Your Honor.
In the play of things, I have appeared, alongside Learned Senior, of course, on the other side as defense counsel, in several other cases at the High Court. And prosecution has always been going fast, including the case we are handling before Justice Kavedza in Kibira. We have always been going fast in such instances. And, Your Honor, this is the reason why.
Your Honor, I have already addressed you. And if Mr. Murama wished for you to have made a decision as to who addressed you first, then he should have expressed that. Then we argue that at some point.
We are not arguing going.
Actually, what I'm going to do is you're both going to
Have one bite at the cherry because it's not the application. That is the position, and I want to demonstrate why they should have one bite at the cherry and not two bites, as counsel wants to suggest.
Your Honor, I can't have that. We don't have a right to apply for bail in the very first instance. So what the state wants us to address you, what the state wants us to address you is who has two bites of the cherry. That is it. I understand it. And I insist to, we are the one who will have two bites of the cake. And there is no cake here. It's very bitter.
But now that it is before us, we may just have to iron this out. Your Honor, there are only 4 non-derogable rights under our Constitution. Article 25, Subarticle A to Subarticle D. Only 4 of them. This one that counsel is applying for is not a non-derogable right. Yes, it's not a non-derogable right. Your Honor, essentially that means is that once an accused person has been brought to court and the provisions of Article 49 F come into play, 49(1)H come into play as regards being released on bond, it then follows that if the state has not filed any opposition, then yes, automatically the court can proceed and consider whether they should be released on bond. Does not mean that the court on its own motion can decide not to grant bond. This makes right to bond not just an automatic right. Even the court on its own motion, minus the prosecution, can say, I am not granting bond because of this and that reason. That's why courts call for pre-bail reports. Even when we are not opposed to bond, they do call for pre-bail reports. But the second limb of 49H is what we want this court to focus on. That actually the third limb, that they have a right to be released on bond on reasonable conditions unless Your Honor, unless a qualifier to that right, unless there are compelling reasons. And how else will an accused person know if there are compelling reasons? This can only be discerned after we have filed an affidavit, as we have done today. So that we now become the applicants who are saying this right should not be exercised or should not be enjoyed by these accused persons. We are the ones who are now blocking him from enjoying this right. And therefore we are properly the applicants. And that is why we go first. Because it is the person who says this right is not to be enjoyed, that person has the onus to show the court why this right should not be enjoyed. And Your Honor, just recently, 2 weeks ago, the High Court sitting in Kibera in criminal of what the accused person is known of. A person dealing in heavy artillery weapons like the one he's posing with on the first attachment as relied on by the IO. You honor such persons exerting such influence on would-be witnesses and are the same persons that Justice Lesit, Justice Korir were discussing the authorities that you have mentioned. They should not be let anywhere near witnesses, Your Honor. And finally, on the last link why we think the accused person should not be released, is that he is the holder of a French passport, 2 passports actually, as documented in paragraph 4 of the affidavit, which passport he still holds on to, and therefore the investigators have not been able to access. And he is also believed to be holding 1 forged passport, which the investigators are still pursuing. This again, therefore, making him a person of concern and a flight risk. Finally, Your Honor, coupled by the charges he's facing, the likely offenses, the likely sentences in the event of a conviction, and the evidence already in place against him, particularly for the gun charges, which we already have hard evidence, particularly for the gun charges, then this, Your Honor, might be impetus enough for a man cornered like the accused person to flee from the court's jurisdiction. We therefore apply to have him held in custody until this matter is determined, Your Honor. We therefore humbly apply. That is all. We rely.
Is charged before court. One of his foremost rights is to apply for bond. There is no provision, Your Honor, in the Constitution or in the Criminal Procedure Code that the prosecution must apply for bond not to be given. Before an applicant, an accused person can, unless the prosecution wants to take away that right. And standing before you, or before Redikavet, neither me nor Mr. Murama can take away a constitutional right. They cannot step forward and say, we will start by making the application for him not to be released on board. It is not provided for. Mr. Murama has quoted Article 49. Article 49, Your Honor, reads from 49 Sabbatical 1 all the way to Sabbatical 2. Not a single one of those provisions provide that the prosecution will or have the right to start by objecting to bail. Whether they file the affidavit or not, the right of the accused cannot be taken away, it cannot be wished away. Your Honor, whatever arguments were raised in the case at Kibera, this court is not a party. I was not a party. We have not been given that ruling. If Rede Kavesa said, it is the right of the prosecution to start by opposing bail. It has not been provided to me, Your Honor, and I have, in the foremost mention, asked the court that I should not be ambushed. But I have absolutely no fear, Your Honor, that the right of an accused person to make application for bail cannot be made a second covenant. Article 49, Article 50, and the entire Criminal Procedure Code. Section 123 and 124 of the Criminal Procedure Code provides for the right of an accused to make the application for bail. Nowhere is it provided that he can only do that if the prosecution confirms they are not objecting. Or if they say they are not they are objecting, it does not provide that then he should sit and wait for them to bring the objections. Then he can say, well, I need not get bail. I refuse that proposition. It is not an accurate proposition of law. Your Honor, I want to and I wish to address you on this affidavit that my very good friend. Or before I get to that, Your Honor, the right of audiences is very, very critical. And the fact that in matters of bail, the accused has the last right of audience, which is what the prosecution intended to deprive me today. Permit me, Your Honor, to address you on this affidavit by somebody, Thomas Odor, Sergeant.
Yes, I'm ready. Thank you. And now turn to the affidavit in opposition to vote.
Thank you, Your Honor. Yeah, it is by Sergeant Thomas Odor. This affidavit, Your Honor, should not see the light of day because it breaks every rule with regard to the preparation of affidavits. The Criminal Procedure Code, Your Honor, does not make provisions as to how affidavits should be done. But we have clear provisions under Order 19 of the Civil Procedure. And those provisions are followed because they are the only legal provisions that guide us with regard to how an affidavit should be done. Order 19, Your Honor, Rule 2. It provides for the making of affidavits like he has done. I don't have a problem with Sergeant Odor making this affidavit. But having said that, he must make an affidavit within the provisions of that rule. Order 19, Rule 3. Affidavit shall be confined to such facts as the deponent is able of his own knowledge. That is why we say, I am able, I am aware of these facts.
Should be in the first person.
You know?
Should be in the first person.
I'm going to, it should also be in the first person singular. Exactly, Your Honor. And where it is not in the personal knowledge of the deponent, then it must declare the source of that information. An affidavit should not be scandalous. It should not be argumentative. 19.5 is the one that states it must be in the first person singular. Your Honor, paragraph 2 and 3, 1, 2 and 3 are well drawn. Paragraph 4 violates the rules. Paragraph 5 it violates the rules. Paragraph 6 violates the rules. Paragraph 7, paragraph 8, paragraph 9, paragraph 10, paragraph 11, paragraph... all these, other than the 3 descriptive paragraphs, all these other paragraphs violate the rules as to construction of proper affidavits. But it goes even further than that. Sergeant Ozoyuana is a very brave man. At paragraph 9, paragraph 16, the Lecit J, and says that Lecit J, he purports to depound what Judge Lecit, a lady we all admire in the Court of Appeal, would depound. Can Sergeant Ozoyuana properly depound for Justice Lecit? Paragraph number 4 of the affidavit, Your Honor, again wrongly depound. My client has a passport, they have not gotten it. They went to his home. They searched everything, overturning everything. They did not demand my client to give them a passport. They do not depound that they asked him for a passport, and he refused to give them a passport. And paragraph 6 then brings up the issue that my client is a flight risk. Your Honor, the law and the authorities now are very, very clear. The fact or an allegation that one is a flight risk is not a compelling reason. This has been stated over and over and over again. On this, Your Honor, I will support, Your Honor,
So that I can plan myself. How much longer are you going to take?
like 10 minutes now, Your Honor, because I'm just going through these authorities very, very
Which
quickly.
you are giving him time to...
Yes, I'm giving Your Honor.
This is the decorum
Mr.
you want us to-
Matungi is next after Mr. Amino. Please, we cannot just disrespect him. He's next.
The difference, Your Honor, is only one. Mr. Murama had an authority on phone, but I told the court, I have gone further and prepared myself well. I have copies of these authorities, which I'm giving him. I'm not catching him by surprise. Your Honor, in the case of Thomas Mudoi Lee, it's a decision, Your Honor, by Judge Ochieng, now the Court of Appeal. Thomas Muthoi, I'm happy, Your Honor, I made a small contribution in that case. It was a murder case, Your Honor. It was the second case after the decision in Munya. And Judge Ochieng expressly found, Your Honor, that the fear that a person would abscond, the fear that somebody will abscond, is not a compelling reason. In the same authority, Your Honor, the judge even found that the fear of flight cannot be said to be a compelling reason because Your Honor, the court, Your Honor, is that if fear of flight or the fear that one would have scored is a compelling reason, if the fear constitutes or is alleged to be a compelling reason. Nobody, Your Honor, would ever be granted bail. And I'll refer 16 of the NDUNG'U decision, Your Honor. At page 13 of that decision, the judge quoted the case of Gatabaki, Dwight Sagare, Your Honor, by Judge Ibrahim. Is well stated as he explained the fear Your Honor, when we speak about the seriousness of, while admitting that terrorism is a serious thing, again, Justice Possesing was not prepared to hold that the seriousness of the charge would be a bar to the grant of bail. Your Honor, all the matters that are on this charge, from count 1 to count number 14, they are all allegations as of now. They are matters that the state you still need to prove, and my client is presumed innocent. And Your Honor, I beg you not to be persuaded by the averment that these charges are serious to debar my crime or to refuse my crime bail. I beg Your Honor to be guided by the Constitution. That is the Constitution. I beg you most humbly, Your Honor, to find that this affidavit by this sergeant is not a document that should be occupying your time at this particular hour. I beg Your Honor to find my client has been in custody for 24 days. I beg Your Honor to consider that my client is willing to abide by such conditions as you may impose. He is not just a foreigner, Your Honor. He's been in this country for over 15 years. He has a work permit as an investor, which is still operational. In this affidavit, Your Honor, there are allegations that he is a criminal. Your Honor, it's only your pen that can condemn a person that you have committed an offense and you become a criminal. Without that, also this sergeant have absolutely no basis of calling my client a criminal or deponing on anything to that effect. But he was free raging to ensure this man remains innocent. Your Honor, I am aware that Your Honor is perfectly aware of all this. If you don't have the luxury of time to argue them and clearly do that. If I had time, I would have wished to cross-examine the subject. But I don't have that much time. I have a client, Your Honor, who is already sickly. He was gravely manhandled and he was coming. His arm is now in a sling. I'm winding up. He's there, Your Honor. You can look at it. You can see it. I urge Your Honor to find that my client is entitled to reasonable bail terms, and I would beg you to admit him to a cash bail of a sum to be decided by you with alternative terms support. My client is even, as a matter of good faith, is even willing to abide by reporting conditions if the court finds it necessary. I pray that. Thank you.
Even the court, depending on the supporting, but like under underlying factors, the court will say no, both will be granted. And so the one was saying, in this matter, the distinguished this opponent, particularly on the gun charges. Coupled by the fact that there are continuing allegations of witness interference, even though indirect, towards the complainant's family. And 3, that we even don't know his immigration status because we don't have 2 of his passports. And we are saying if this court were to look at these 3 grounds as fronted, cumulatively, then the court will decide to limit bail and bond as envisaged by the use of the conjecture unless. And Your Honor, Philip Leviman and Dr. Maende, the court observed that witness interference does not have to be direct. So that we cannot expect Sergeant Otho to come to court and tell us that indeed we have an OB filed in Kenya that the complainant was threatened by this accused person. But the courts have held that this can be indirect, directed towards even people of close familial relationship, like we are now seeing by way of this affidavit. Your Honor, it is our view that affidavit evidence cannot be ignored. The good sergeant, being an officer, has presented what he has, information that he has, that he believes is being used by the accused persons to pervert the ends of justice. And Your Honor, it is for this court, on a balance of probabilities, to look into all the grounds that you have fronted vis-a-vis the rights of the complainant, the victim, his family, and the accused person, who we don't know even his status at the moment, and then now consider what is the best way in interpreting the provisions of Article 49, sub-article H. We do not know the immigration status of this person. He has 2 passports. We do not know where he will go next. The accused person is literally cornered with evidence as will be presented shortly by the prosecution. And to that extent, we are not saying when a man is this corner, the only option we have to give him this Bible is to get back. We are okay to go.
Yes, you did. So just a minute. This is the one for Dwight, isn't it? Just a minute. What an minute. Hold on. I don't know where it is. So I have Abu. Before the court makes a decision, that a pre-bail report is presented. Let the probation office, I'm not sure there's an officer in court, prepare a pre-bail report for presentation on the 3rd of March, Mr. NDUNG'U, 1 week from today. The court will receive the report and give a ruling date. Accused to be remanded in custody. Accused to receive treatment for his ailments. Shall you please write for me another for the accused to be treated? Important to give a ruling date. Thank you.
You know, the OCS Lametta has been holding my client for the last 24 days, but this afternoon he lacks capacity. Check.